So what is copywriting and what is trademarking? I get this question a lot as a lawyer. It's very can kind of be confusing for people who just don't know. This is going to be a short video because I know complex subjects like this can be very time consuming and it'd be hard to follow. Like I always suggest in any video, always consult a lawyer. Things might be just different depending on jurisdiction, and your case just might just be different. So what a lot of people don't understand is that I make these YouTube videos and posts or what have you based on my practice of the law. So now, especially during COVID-19, I'm getting a lot of people who are starting their businesses, coming up with business ideas, whether it's an app or whether it's a new device, a computer or whatever it is, medical device, all kind of things. So I'm getting hit with a lot of questions. And the reason why I put these videos out is to offer a lot of insight for people who are just trying to figure it out, just trying to maneuver and make the best decision from a legal standpoint. But like I always say, you always want to consult a lawyer. So let's go ahead and jump right into it. What's the difference between trademark and copywriting? And this, I'm going to read a little bit off the screen because I want to make sure I be specific, not specific. A trademark is a word, phrase, symbol, or a design that identifies and distinguishes the source of the goods of one party from those of another. Okay, so trademark is something like a like Nike swoosh, Apple, things of that sort. Basically, what you're trying to do is just saying, if you see you see a little symbol or anything that says TM, that's what it means, trademark. So basically, that's just to show that, hey, this is the product that you're intended to buy, right? So we all know about the knockoff Louis Vuitton purses or Louis Vuitton, or how you want to say it for some people, coaches and Nike shoes, Air Jordans, always knockoffs and things of that sort. So that logo or thing is supposed to, or symbol is supposed to denote that this is a true, authentic product of that. Now, let me go one step further. A service mark is a word, phrase, symbol, and or design that identifies and distinguishes the source of a service rather than goods. So this goes to, for me, vegans, or if you practice Jewish customs, kosher food, things of that sort, or for me being a vegan, there's no products, animal products in the products or anything like that. And I go to certain companies that produce this stuff that I know is going to be, no animal products in it. And, for people who are in the Jewish religion, kosher. So you know that it's a certain mark on there. I think it's UD or something like that on the back of the packet that is kosher or vegan. So copyright. So without that being said, so what is copyright? So once again, I'm reading straight from my screen, so excuse me for diverting my eyes. Copyright protects original work of author's issues include literary, dramatic, musical, artistic works such as poetry, novels, movies, songs, computer software, architecture. Okay, very simple, right? So trademark is just a symbol to say where this came from, or this is authentic, this is my brand. Copyright is saying that this is something that I created, right? This is like I said, a song. Like you always see copyright infringement of songs, and everybody who is old enough to know LimeWire and I think it's Napster or something like that, where people can download movies and download music videos and things of that sort. So you have those entities, and that's what copyright is. Basically, these are for my creative folks out there. I created this from scratch, or I hired someone, subcontracted this out for someone to create this for my business, and I want this to be protected. And I'm saying all this. The reason why you would have all this in place, specifically from a business standpoint, is because you just never know if somebody tries to use it and they gain a profit from it. Two, you want to make sure it doesn't dilute your brand. So I know a lot of people who put a lot of stuff in their clothing design that, you don't want anybody just come and take it and make money off of it. But then also you don't want to get, you don't want to get knockoffs, right? So if somebody started doing a knockoff version of your product, guess what? That dilutes your brand. So what I mean by dilute your brand is if you're selling, let's say, a dress for $5,000 and somebody creates a knockoff for $100, $200, guess what? If you have $105,000 dresses out there and somebody can make 1,000 of the same dress for $100, guess what? That dilutes the brand. And companies take this very, very seriously, as you should as a business owner. One thing I would like to add into this, I didn't put this in the title, is a patent. Because all these things are interchangeable, not interchangeable, but are used interchangeably incorrectly, okay? I'm not saying all these are changeable. I'm saying that a lot of people use these different words wrong or incorrectly. So I just kind of want to demystify that. So a patent is a limited duration of property rights related to invention granted by the United States Patent and Trademark Office in exchange for public disclosure of the invention. Patentable material includes machines, manufactured articles, industrial processes, and chemical compositions. So this is, let's say, the process in your computer. You know, it's a patent on that. If it's a process in your phone or anything like that, that is a patent. So I would like to say trademark is where the service comes from. Copyright is something you created. Whether it's a literary, a novel, movie, computer software. Patent is something like a machine, manufactured articles, industrial processes, stuff like that. So I'm hoping I'm not boring you too much with that. A couple things I would just say that a lot of people don't know in regards to patents and all this, that patents, copyrights, trademarks, is that a trademark registration can last forever, as opposed to, and I think a patent is 50 years if it's a design patent. Utilities patents and plant patents can do 20 years. And then copyright, depending on, can be 95 years or 120 years. 120 years from dedication, which is ever shorter. So it's a lot of little small nuances that I'm hitting you with, and I have not covered in depth. But essentially, the purpose of this video is just, hey, here's the differences. And if you wanted to do one of those three, or all three of those, or all four of those, because I did say service mark, all four of those, excuse me, guys, consult a lawyer. I would love to, chat with you and just go over the differences. I know I kind of might have breezed away some small technicalities and like the difference of the years, but once again, this video is just just wants to give you an overview of it, something quick, simple. And if you have any questions, definitely just give me a call, 205-222-9815, or you can text me at the same number, which is 205-222-9815. Hold on, it's 32. Sorry about that. 205-222-9815. You can call me on that, text me on that. Follow me on my social media. My social media handles, all my social media accounts are Get Rice Now. That's GETRICENOW. Or log in on my website, www.ronnieorice.com. That's www.ronnieorice.com. I hope you guys have a great day.